Thank you, Michael. Happy to be here at Venture Cafe. I have presented at the cafe before, but obviously in a different time and a different circumstance. But the Zoom format and the fact that we have a nice small group, I think will lend itself to an interactive and educational type of presentation that hopefully gives you a little bit of a different perspective on the way the current administration is not only addressing immigration matters, but frankly, other matters. And I think, what I'm going to be trying to do here is really show how something that I know intimately, which is immigration law, and can be used as a touchstone for understanding the way this particular president functions with regard to laws and regulations and control. Um, as far as my professional qualifications, I think there was a resume or a blurb up there, but essentially I'm the managing partner for Green and Spiegel, which is an immigration law firm, which is headquartered in the United States. We have multiple offices throughout the country and in Canada. I also teach as an adjunct professor at Temple University, where I teach a course on law practice management, another course on advising global corporations, and an immigration law class as well. So, I feel like I can not only bring a little bit of the practical, but the academic to this panel discussion. But like I said, rather than just doing Q&A at the end, I obviously have a little bit of a set agenda, but I'm not married to it. I really do encourage you. I think if you hit the space bar, that's a quick way to unmute. If you want to just ask a question, feel free, or you can, as Michael said, you can drop it in the chat box. So without further ado, you know, I think what needs to really be understood is how has immigration been treated over the past 40 years by the various administrations? And how does the Trump administration, which is a Republican administration, play into that narrative? Because I think most people don't realize today that historically speaking, the GOP and the Republican administrations have been far more immigration and immigrant friendly than the Democrat administrations. In fact, in the 60s and 70s, the Democrats, because they were so closely tied to workers and unions, were actually far more restrictive in their approach to immigration. They were the ones that said US workers first. They were the ones that said we do not want additional visas. And this is most highlighted actually, and a lot of people don't realize, but the last time we actually had a true amnesty in the United States for people who don't have status was under the Reagan administration. And essentially by paying a fine, if you were here without status, you could apply and get permanent residency to the United States. Famously, during that, the Immigration Act of 1986, Reagan instituted an obligation for employers to ensure the legality of their workforce. And it was this requirement that everybody who takes a job, whether you're a US citizen, green card holder, or foreign national, has to complete a form called I-9. And I don't know if any of you guys have ever been hired in the United States, but in completing Form I-9, you're essentially attesting to your eligibility to work in the US. And Reagan said at the time when signing this bill that because employers are going to be responsible for the legality of their workforce, we will end illegal immigration to the United States. Okay, well, 12 million illegal, 15 million undocumented workers later, obviously that didn't work. And one of the reasons why, and this is something that's actually missed, is that most people who come to the United States without status are doing so for economic gain. I mean, the statistics show it's something like 97% of people who cross the southern border illegally are coming to provide or send money back to their families in Latin American countries and Mexico. And our current immigration system does not have a mechanism for year-round low-skilled workers. There is no visa for housekeepers. There are no visas for dishwashers. There are no visas for construction workers that are operating year round. We have seasonal low-skilled visas for people that might be operating in, the foodstuffs industries and harvesting agricultural products, or people that are doing temporary seasonal work, like foreign nationals that you tend to find at ski resorts or down the shore. But in terms of a year-round, low-skilled visa classification, there is no mechanism for somebody to enter the country legally. Yet, we have a population within the United States that, irrespective of unemployment rates or the state of the economy, will not take certain jobs. Those jobs are filled by foreign nationals. The original draft of the 1986 Immigration Act had a low-skilled visa classification in it, and that was the intention. But the Democrats blocked it from becoming part of the law because the unions thought that it was going to affect the availability of work of union members. But when you hear people talk about immigration problems within the United States, when you hear people talk about the dreamers and what to do about people who are here without status, rarely do people actually talk about the cause. We always talk about the effect. Should these people be sent home? Should they be given amnesty? Do we need to build a wall? But the reality is that our laws do not allow or accommodate for the millions of people that are in the United States to perform low-skilled work. And the blame for this falls on both political parties. And frankly, it's the reason why I'm a registered independent. If you guys are curious, my voting record tends to be Democrat. We'll get to the Trump issue a little bit later. But, the reason why we have undocumented workers is because we do not provide a mechanism for them to be here legally in the first place. And until we recognize that, we will continue to have this issue. You can't look at the effect and provide a solution for the effect without examining the cause and providing a solution for the cause. And I think even as you listen to the upcoming presidential debates, as you listen to the vice presidential debates, if you listen to messages coming out of people who are running for Senate and Congress, and if they have an immigration policy and they talk about it, they will not address the fact that we still as a society have intentionally created a subclass of individuals who perform essential labor to keeping the country going, but we don't give them any protection. And even when we had Obamacare or the Affordable Care Act, even if you pay taxes as somebody who doesn't have status, you're not allowed to enroll in the Affordable Care Act. And that's been in there from the very beginning. It's not like Trump took that away. But now we force those people to sort of use the emergency room as their primary care physician because we won't allow them to get insurance. And I think until we as a society in America recognize the fact that we have this issue, we're going to continually be plagued with issues of undocumented workers. Now, that being said, the focus of what I want to talk about and what I want to examine from sort of this allegorical perspective is the effects on business immigration, on people who are coming here to invent, people who are coming here to work, entrepreneurs that are seeking venture capital money in the United States and access to visas that allow it, and how the Trump administration has manipulated the legal immigration system through a series of executive actions. But before we get there, let's continue down this path. So we have Reagan, who says, I am going to have an amnesty. We are going to solve the problem of undocumented workers. You have George H.W. Bush, who entered into the NAFTA agreement the first time around, creating visa classifications and free trade between Mexico and Canada and the United States. You have Clinton, who famously expanded immigration for tech workers under the H-1B visa program during the dot-com boom, but correspondingly was responsible for the Defense of Marriage Act, which limited same-sex couples from getting immigration benefits until the Supreme Court overruled that in 2013. You had George W. Bush, who further took this idea of bilateral free trade agreements and created agreements with Chile and Singapore, as well as Australia. And it seems random, but we entered into trade agreements with those countries to allow a mechanism for US businesses to operate on those continents. Associated with those trade agreements were visas and the ability to come into work in the United States, an expansion of the labor pool. And Obama obviously did the Dreamers Act, to give status to those who were brought here as children without status, but also among immigration circles was known as the deporter-in-chief. Immigration advocates were not happy with Obama and the fact that up until the Trump administration, they had removed the highest number of people without status from the United States of any president that preceded them. So where does immigration policy really lie? Before I get into Trump, and my point is really that Trump is not really adhering to the traditional Republican mechanism in view of commerce as to the importance of immigrants. It is suggested that for every immigrant that comes to the United States, 1.8 jobs is created. And from a macroeconomics perspective, the only way you really have economic growth is through population growth. And if you look at Philadelphia, which was a city that had a truncated population from 1950 to 2000, the only reason why we actually have had growth in the city since that time is attributed to new immigrants, new Americans, people coming and settling in the United States and choosing Philadelphia. So how does Trump get it done? Now, here's the question that I have for you guys, and it can be rhetorical if nobody wants to go off mute, but what was it about Obama that became problematic as it relates to immigration? Does anybody know how the Dreamers were actually given DACA status? Well, it was done through executive order. And executive orders are extremely dangerous, in my opinion, because it is allowing the executive branch to circumvent the legislature to come up with their own rules and laws. And under Obama, there was an attempt at a comprehensive immigration reform in 2013 that failed in Congress. And Obama famously said, you know what, I cannot work with this Congress. I am going to fix the immigration problem myself, and created the DREAM Act. But the DREAM Act is a misnomer. It wasn't actually an act. It was an executive order that provided the ability for individuals who entered the United States without status before the age of 18 to obtain deferred action, meaning that the government would not pursue removal of them from the United States, and also conferred a benefit of employment authorization. But the problem with executive orders is that these executive orders can be created by a president and can be also taken away by the president. And that brings us to Trump. Trump loves executive orders. I don't have the exact statistics, but I know for a fact that in his first 4 years, he passed more executive orders than in any single 4-year period of any president. And the executive orders on immigration, in particular, have been so far-reaching and so dramatic in the way that they've changed the immigration system that it shows the ills of presidents using this imperial power. Gone are the periods of a bill being brought into Congress and debates on C-SPAN and on the floor of the Senate. Gone are attempts at the rulemaking procedure where something is published in the Federal Register and there's a notice and comment period. When an executive order is signed, until it is enjoined as being unconstitutional by a district court, it continues to exist. And the one that was sort of like the touchstone for this was the travel ban. Some people refer to it as the Muslim ban. And that came in January of 2017. On a Friday night at about 8 p.m., they released an executive order banning people from certain countries from coming to the United States, and they were all Muslim nations. In doing so, the Trump administration intentionally created havoc. And I mean, it seems like eons ago because of what we're dealing with these days. But if you remember, it created pandemonium. People filled the streets. There was protests. People were going to the airports to protest. But the people that were harmed the most, and I represented one of these families from Syria, they were mid-flight when this executive order was issued. They landed in the United States and were refused admission and had their visas canceled. And the one family that I represented had waited 14 years to get their immigrant visa and were turned away. Because of a policy that, frankly, if you read it, looks like it was written on the back of a Denny's menu in crayon. It was obviously so poorly drafted that an injunction followed shortly thereafter. They modified it. That one was enjoined. And then finally, they come up with a third executive order, which is still in effect. So I think what you have to really see there is that the executive order has become a very powerful tool. And it's not limited to immigration. It's done with environmental stuff. It's done with various like tax benefits or relief benefits. Like we just had an executive order from the president because he felt like Congress wasn't acting quickly enough on another bailout plan for the population because of COVID-19, where he arbitrarily puts a moratorium on the payroll tax. Well, that didn't go through Congress. That was just done as an executive order. And it's this sort of behavior that creates a lot of unpredictability within the United States and makes it challenging for us as lawyers and frankly as corporations and individuals for planning purposes. So, it is really something that we have to be mindful of, not only for the purposes of this discussion and what it means for immigrants, but frankly, we have to ask ourselves as a society, what is the impact of the executive order and what does that really mean for the Constitution, the division of the branches of the government, the checks and balances system? Are we moving away from that? If we allow the executive branch to legislate from the executive pulpit, so to speak, have we removed the necessity for Congress? Has Congress become almost less relevant? And these are very serious questions because as we push further and further towards executive actions, we push further and further along towards an imperial president, which is exactly what this country was not founded to do. And the proliferation of executive orders is not limited to Republicans. When Obama ran for president in 2008, he ran on a campaign that said, I am not going to do any more executive orders. I will not do any executive orders. And what did he end up doing? He ended up passing more executive orders than any previous president before him. Now, is this a problem with Congress? Is this a problem with the further dividing of the political parties where they've become further and farther from the central so that they can't come together to actually agree on certain bills that need to be addressed or changes that need to be made in Congress? Maybe. But does that give the president the right to change things? So let's dig a little bit deeper into immigration, right? Let's see what immigration is going on. The first real one that I want to talk about is the USMCA, which replaced NAFTA. It's completely within the president's right to negotiate a bilateral, trilateral free trade agreement. Absolutely nothing wrong there. What was interesting is there's a visa classification associated with it called the TN. The TN is a funky visa classification. And as our Canadian immigration attorney online will probably agree with me, It's odd because it lists very specific categories for which people can get visa classifications. Most visa classifications have sort of this test like, is the job a professional job? Does it require a degree? Does an individual have a degree related to that field of endeavor? With the TN, they list out a certain number of occupational classifications that individuals can hold in order to get the visa. And there was a real hope when they were coming to form the new agreement that they would modernize that list. Because it was done in the early 90s under the Bush administration, there's actually only one true computer related job, one IT job on there, which is computer systems analyst. If you happen to meet a Canadian in the United States and they work in the tech sector, if you ask them if they're a computer systems analyst, 99 times out of 100, they will say yes, and they will think that you are some sort of like a soothsayer, that you can read their minds. But that's because there's really only one occupation. Well, what happened with these negotiations is very fascinating because Trump got in a little bit of a tiff with Trudeau. And for a little while, Canada was excluded from the negotiations of the new NAFTA agreement. And when Trump took this to the Mexicans, he said, I'm eliminating the visa classification completely, to which there was tremendous outcry. And instead of pushing, hopefully, towards a modernization of the way the visa could be used, everybody was very thankful that it didn't change at all. So now that the USMCA is in effect, it can't be modified for 13 years. It means we're stuck with the same visa system we've always had. And I think this is sort of a theme of the Trump administration. We are going to take everything away, and then somehow he thinks you are thankful and he's doing you a favor when he puts back little pieces of it. And that has become quite fascinating as we look to the pandemic response, which we'll get to in a little bit. But this is something that we see over and over again with this particular administration as it relates to immigration. The one that's had like the greatest impact are the ones that are changing the way the adjudicators think about visa classifications. And in April 2017, Trump passed something called Buy American, Hire American. And it's not lost on me that the acronym is BAHA, because I feel like they're laughing at us a little bit. But through this executive order, Trump instituted a new legal standard within immigration, which said in order for a consular officer or an immigration benefits processor to issue a visa classification, they have to ask whether or not this individual will negatively impact the US labor market. Mind you, this is found nowhere in the regulations. This is found nowhere in the statute. It is simply an executive order that changes the adjudicative trend. And the effect has been spectacular. When this first came in, I was like, this is just like lip serve to the base. It's not actually going to have any sort of change. But now we have enough empirical data to actually see how it's changed. The H-1B visa, which is your like traditional tech worker visa classification, anybody that comes to the United States as a foreign national and ends up going to school here or goes to school here and then gets a job will have an H-1B. Under the Obama administration, 17% of all H-1Bs that were filed were given a request for additional evidence, and about 7 or 8% of them were ultimately denied. Under the Trump administration, in the most recent fiscal year, the number of requests for evidence has gone up to 69%, and the denial rate is almost 30%. The law itself has not changed one iota. The regulations have not changed. But because an executive order changed the interpretation of the law and evoked a different standard, the net effect to the United States and the worker has changed tremendously. But this really affects not only the individuals, it affects the companies that employ them. If you're a business and you're looking to fill a job, are you going to hire somebody where you know there's a 30% chance statistically that that individual is not going to be afforded the visa classification? And for my firm, it has been a real challenge because we now have to put a lot more effort into getting cases approved than when we ever did in the past. It changes our profitability because we bill on a fixed fee basis. And I'm happy to talk more about law firm economics if anybody's interested. But it's made it so that we have to work a lot harder to buck the adjudicative trends. And I'm proud to announce like that our firm's denial rate is only around 2%, but I can tell you it takes us twice as long to get there. And our fees have not increased by 100%. And that's the reality of the situation. You have to work harder to get there merely because of an executive order that changed the adjudicative standards. The other effect, and I would invite my colleague from Canada to chime in here, but I can tell you a quick little story, but like for my office in Canada, they've doubled in size since the Trump administration has taken office. And the reason is that more and more US businesses are looking to use Canada as a place to put foreign workers when they're unable to secure visas for the United States. As we have contracted our availability of work visas, Canada has really opened up. They've created programs that specifically target the tech industry and see that as a benefit to the citizenship of Canada on the whole. People don't realize this, but Toronto is an amazingly cosmopolitan city. More than 50% of the population was foreign born. And Microsoft, when they were looking for a location to open their new artificial intelligence headquarters, decided to use Montreal. And we've had this increasing phenomenon that is only exacerbated by the pandemic, where people don't need to be physically present in the offices anymore. And a lot of companies are happy having workers available that can operate within the same time zone. And this phenomenon is called nearshoring. Now, mind you, it's extremely difficult to get into Canada at the moment because of quarantines and the borders being closed. But normally, if somebody's unable to get an H-1B visa, it takes tons of prep time. We talked about the adjudicative standards and the delays, and there's actually a lottery because it's oversubscribed. If you have an employer willing to hire you and you're in the tech field in Canada, so I think it was Sophie was that right, Michael? Sophie was the Canadian attorney? Yeah. Oh, you're muted. Sorry.
Yes. Yes,
Sophie, minus the pandemic, how long would it take you to get a tech worker from the United States up to Canada?
Unfortunately, I actually work primarily in refugee law, so I don't actually have the background. Sorry.
Okay. Well, my partners tell me it's about 4 weeks, which is amazingly fast to what we have here. So it's 2018. We're 2 years into the Trump administration. It's our holiday party. And I'm giving this speech to my staff. And I'm talking about how absolutely amazing it is that they persevered during these difficult adjudicative times. I'm thanking them for their service and all of their effort. My partner from our office in Toronto is in the back saying 4 more years, 4 more years, because their business is booming as a result of the Trump immigration policy. And the irony is that these efforts that are supposedly in place to protect US workers are forcing jobs out of the United States to Canada. And in turn, those secondary and tertiary jobs are going to Canadians and not US workers. So who's actually benefiting? And is this a policy that is merely in place to give the appearance of doing something to help US workers? Or is it a policy in place that is actually helping US workers? And you'll hear arguments on both sides of the fence. Like, obviously, I'm a believer in immigration. I wouldn't be doing what I do for a living if I didn't believe in immigration. But don't make any mistakes about it. The effects are real. In fact, I read a recent article in Forbes that said Toronto has the fastest growing number of jobs within the tech sector in North America, more than Silicon Valley, more than New York City. Why? It's immigration policy that's driving that change. So that simple buy American, hire American, that simple executive order that seemed to say nothing has had an amazing effect on the ability of people to work in the United States legally and get visas approved. But it doesn't stop there. There's been so many more examples of this, and it's like increasingly frustrating. But the one that really pertains to, individuals that we work with and entrepreneurs, there's a visa classification called E2. I absolutely love the E2 visa, right? The visa pretty much says is if you invest a substantial amount of money, and substantial is like a legal term of art that essentially means you've invested money enough to commence operations of a business within your industry. So if you're service-based business, it might be $70,000. If you're running a bakery, maybe $200,000. If you have invested a substantial amount of money, you're creating jobs for US workers, you can get a visa in order to direct and develop your enterprise in the US. And as long as that enterprise remains real active and operating, you can keep extending that visa classification. It's not available to all nationalities. It's, there has to be a treaty of friendship and navigability between the United States and the foreign country. So most notably missing from the e-visa scheme are the BRIC countries, Brazil, Russia, India, and China. But for our European friends, for our Canadian friends, for many of our Asian nationals, you do have access to this visa classification, which is used to create new ideas. And I think it's an important point to echo that 1/2 of the Fortune 100 companies in the United States were founded by immigrants or the children of immigrants. Like, notwithstanding the current administration, immigration is in our DNA. It is who we are as a people. Unless you're a Native American, your family came here from somewhere else. And this ability to come to the United States and have an idea and fail and pick yourself up and try again, it's just part of the culture. And, I once asked a group of immigrant entrepreneurs I was helping, like this is maybe 10 years ago. And I said, why do you want to come to the United States? And I said, the United States is the one country where you are applauded for trying. If you go to a cocktail party and say you're an entrepreneur, people are interested in what you have to say more so than the guy that's like the rocket scientist standing next to you. Like, we love entrepreneurs. Like, Shark Tank has like, I don't know, a million episodes and keeps getting renewed because we're curious about invention. We're curious about this concept that says if you have an idea and you can take it and you can roll with it, that you can become successful even if you started with nothing. And what I find most amazing about talking to entrepreneurs, and I know Venture Cafe is like this. I'm sure you've had other cafe sessions with people that have really become successful entrepreneurs. When you ask them how they did it, they're not going to tell you how they succeeded. They're going to tell you about all their failures before they succeeded. They're going to tell you about how they slept on their buddy's couch for 2 months, how they ate ramen in the back of a garage, how they had to borrow $50 from their uncle just to like pay rent. And the United States is really, and this is what this group of immigrant entrepreneurs told me, is like, even for trying, you're applauded in the United States. And if you fail, you pick yourself up and you try again. In a lot of countries around the world, if you fail, you're labeled a failure. And you can't pick yourself back up. And that's what's really fascinating about this particular visa classification, the E2, because it is really embraces that spirit. In fact, if you read the preamble to the regulations for the E2 visa classification, it says to the consular officer, this is a visa classification created on a treaty of friendship and amicability, and it is from this perspective that you should adjudicate these visas. And one time, not too long ago, I had the pleasure of sitting down with the visa chief from the US Embassy in Paris, and we were just talking shop. And he said, Jonathan, the E2 visa is like the only visa classification where we go into a visa interview with a predisposition that we are going to approve the visa, whereas other visa classifications, the individual has to show why they are qualified. They want to give you the benefit of the doubt if you are an entrepreneur. Well, the Trump administration took that away. And that buy American, hire American, that language has now permeated those regulations. So now if you go and look up E2 visa classification in the Foreign Affairs Manual, which is like the law that consular officers use, it has that line, this visa classification is predicated on a treaty of friendship and amicability between the United States and a foreign country. It's from this perspective that you should adjudicate the visa request in front of you. And then the very next line says, but don't approve it if it's going to affect a US worker. And it's had a dramatic effect on approvability. It even goes a step further because there's something called the reciprocity table, which dictates how long a visa can be issued for. The E2 visa traditionally has been issued for 5 years. Well, Trump gets in a little bit of a argument with Macron from France, and all of a sudden, the French E2 goes from 60 months down to 25 months. So from a visa that was valid for 5 years to a visa that's valid for 2 years. Dramatically affecting the predictability. And frankly, as many of you guys know, if you're coming to the United States with a new idea or you have a new market, you're not going to be able to hit it right away. It might take you more than 2 years to get it off the ground. If you're not really cooking by year 3 in a non-pandemic universe, maybe you should think about doing something else. But 2 years is often not enough time for a new idea to germinate. We're taking away that ability. But it doesn't stop there. We didn't only do it to France. We did it to Australia. We did it to the Netherlands. And it was all done under this guise of reciprocity. And what does that actually mean? And how does that affect predictability? And the fact that it wasn't done through a rulemaking procedure further amplifies the effect of the executive order. Now, during the pandemic, things have been really crazy. There's a section of the Immigration and Nationality Act called 214F. And it literally gives the president the power to cut off the flow of people coming to the United States for national security purposes. So when Trump banned people from China in January of 2020, it was like January 28th, from entering the United States, if they'd been in China within the previous 2 weeks, that was completely permissible because it was done under the fact that he said that this was affecting the health of the United States. We have further banned people from the EU, similarly, the UK, Brazil, and Iran. They all are blocked from coming to the US if they've been in those countries within the last 14 days. It doesn't stop you from like going to somewhere like Mexico, hanging out in Cancun for 2 weeks and then entering the country. It doesn't stop you from going to Morocco and doing the same thing, or Turkey. But we've been blocked from having direct access to those countries. That is permissible. And then in May, Trump did something that had the most dramatic effect that I've seen. And I like to call this like the tweet heard around the immigration world. But one night after giving one of his presentations on the state of the virus, he sends out a tweet that essentially says, "We're ending immigration to the United States." My God, let me tell you, like, I was up for 15 hours straight. Texts, phone calls, emails, everybody was worried. They come out with an executive order, again, under 214F, that pretty much just limits it to immigrant visas for the diversity lottery program and non-spousal family-based cases and employment-based cases for green cards issued abroad. And people were relieved. People were relieved. They were like, you're going to take away all of immigration. Oh, no, it's just this part of immigration. And that's the weird thing that this administration does. They like hit you over the head with something massive, and then they pull it back, and it's not as bad as what it was before. So you're like, okay, I can live with this. Whereas if they said that they were going to end immigration in the United States and were blocking immigrant visas for diversity lottery winners, for family members, for employment-based, people would have been outraged because it went from all of immigration to this subsect of immigration. It was almost like a relief. Now, just the other day, I think it was 2 days ago, the use of this executive order for the diversity visa lotteries was deemed invalid, well, not invalid, but an injunction was issued. So they can process them now. But interestingly enough, Trump, by cutting off every single immigrant visa for those who are not immediate relatives, and when I mean immediate relative, I mean a spouse or a parent, they've effectively ended the chain migration, which Trump was railing against for so long. By cutting off the immigrant visa flow for workers, it pretty much forces them to use an internal mechanism, because Trump can only affect the flow of people into the United States and cannot affect the flow of people within the United States. But 12 weeks later, he comes out and says, you know what, I'm banning the issuance of new visas in the H visa classification, which we talked a little bit about, and the L visa classification, which is for intercompany transferees, H-2B, which is the temporary seasonal workers, interns under the J-1 visa program. Dramatically changing the flow of workers. And there's been outrage, but again, because it was founded within the section of the law that authorizes the president in the name of national security, and this time it was because of high unemployment rates, this law has pretty much remained intact. And now we have to go through all sorts of hoops to get people into the country. You have to get these waivers. You know, so like if you have an executive that you're transferring from one branch of your company to a branch in the United States because they're going to be heading up a new initiative that's going to create tons and tons of jobs for US workers, you got to get a waiver. You've added another layer. You've added another aspect or process to getting somebody to the United States. And by doing so, you've eliminated that predictability that the businesses crave. How are you going to be able to rely on the fact that this person's going to be here in a certain period of time? So the administration pulls back from this very aggressive posture and starts giving us a list of criteria that will qualify somebody for a waiver to this executive order. And if you're curious, the proclamation is 10,052. Just to kind of give you an idea, that means that the president had issued 10,051 executive orders and proclamations prior to this one. Just to kind of give you a sense of the volume of the legislation that's coming out through executive order. Now, not all of those are going to be executive orders pertaining to the creation of new laws or regulations or semi-laws and regulations. A lot of them deal with like political appointments and stuff like that, but still, that's a tremendous number. So they came out in August of this year, August 12th, 2020, with a series of criteria which you can qualify for an exemption. And if you look at the H-1B one in particular, because we've been talking about it, they said you can issue an H-1B visa and you have to like meet two of a certain amount of criteria. But the one that really strikes me is that the offered wage has to exceed the prevailing wage by 15%. Meaning you have to show that this foreign national is going to be paid more than a standard US worker. But that's nowhere in the regulations. It's a non-existent standard that employers have to pay more. It is crafted completely out of thin air. No basis in law. And that's the part that is really frustrating, right? Because now we have to wait for an injunction, a court challenge to deem this to be invalid, to kind of get us back, and whether or not there's a aggrieved party that's actually going to file a challenge, and then you have to have a district court agree with that challenge. This is something that is being made through executive fiat. It is not coming through the legislature. And this is the point that like I'm trying to really highlight, because it doesn't only pertain to immigration. It pertains to so many areas and facets of the law. And the reason why this country has been successful for so long is because we have this checks and balance system. Because we have a rule-making procedure where public gets to comment before a regulation becomes effectuated. And we've thrown that to the wayside. And it keeps getting more and more pervasive and prevalent. And my concern is that if we allow this to continue, we're inching closer and closer and closer to an imperial president, which is very dangerous. So it's not only about Trump. You know, look, I'm an immigration lawyer. I represent immigrants. I'm in favor of immigration. I believe that when it's done right, we all win. You know, the companies get good workers. Foreign nationals get to come to the United States. They create jobs for other US workers. We all benefit. But when these things are happening and changing arbitrarily, how does that effectuate the immigration system? And what does that mean for the future of the country and the very tenet and principles that we're founded on? Prior to the Trump administration, and I've been working in this field since 1999, I had sued the government 0 times. 0 times. If I got a denial on a case or I took over a case for a denial, I would simply refile and try again and hope that better legal work would get a better answer. I have now sued the government over 30 times since the Trump administration has taken office to deal with these arbitrary decisions based on, does this affect a US worker under this Buy American, Hire American? And we've won every single case that we've filed. Most of them, we filed a complaint and they approve the case before they even have to answer the complaint, because the administration doesn't want to create case law that is contrary to their effect on the masses. Michael, it's almost like saying, like, if you leave this job, you have a non-compete of X amount of distance, or you have to pay this amount to get out of your non-compete, right? You see that all the time in contracts. A lot of times that's done as a deterrent. You know, it doesn't actually really have teeth because it's not worth defending. That's the Trump immigration policy. We know that these things aren't really going to hold up if we get challenged on them, but if we put them in place, it's going to change people's behavior. And if we change their behavior and they don't file for visas or they don't want to come to the United States, then we've effectuated the policy that we want without changing the law. But if you call them out on it, they don't want to create case law that's not in their favor. So they acquiesce. So now all of a sudden, we've gone from being benefits processors, and I used to describe myself essentially as like a glorified legalist, yeah, glorified travel agent, right? You know, we're just a really expensive travel agent. To now I'm like a freedom fighter, part of the resistance, because we have to use litigation as a tool to advocate on behalf of our clients. And if you can see that within the immigration system, you can only imagine how pervasive and prevalent it is with all corners of legal, you know, jurisprudence and regulations within the United States. So I hope that that was somewhat insightful into what's going on. I know we only have a couple of minutes left. I don't know if anybody has any questions, but I'm happy to field a couple if there are any.
Yes, if anyone has any questions, please unmute yourself. Go ahead.
Sophie has a hand up.
Hi, so thanks so much for that. That was so many fascinating insights. You've really changed my my perspective on a lot of things. So thank you first. And I wanted to ask you maybe selfishly about an asylum issue, which I recognize may not be your main focus, but in Canadian refugee law, we are constantly talking about the Safe Third Country Agreement with the United States, which, for those who may not know, basically prohibits most people from making a claim for asylum at the Canada-U.S. border at an official port of entry, which then basically incentivizes people to cross irregularly into Canada. And you know, it's not just a topic of discussion here among lawyers, it's also in the news, public discussion, it's a political issue. So I wanted to ask you, in the US, are you as obsessed with the STCA as we are?
So, yeah. And do you have a second part to that question?
Yeah, well, just generally thinking among lawyers, among the public official circles, and have you been following the latest drama in our federal court, which has recently declared it unconstitutional?
Yeah, I have been following it with great fascination because so that Safe Third Country harbor thing is actually really fascinating because of the fact that, like, we have so many people in the United States that, or frankly stuck at the Mexican-U.S. border, who are claiming asylum, who might ultimately want to go to Canada instead, and then they can't, right? It does not get nearly as much attention as it gets up in Canada, not even close. But I'm very curious as to see what happens with the Canadian courts, because, you know, if the United States is deemed not to be a safe third country, or if that's deemed to not be constitutional under Canadian law, it could open up the floodgates for people trying to claim asylum at the Canadian border. And I don't know it's kind of funny because like right now, Canada is like primarily very, very pro-immigrant, but I'm sure, Sophie, you remember the case with the banks from a couple years ago where a number of people got laid off because they were essentially like retraining their workers, and that actually pushed a severe contraction of the Canadian immigration system. So it does not come up as regularly as it does on like my Canadian immigration news feeds that I follow, but it's certainly something that I'm monitoring pretty closely.
Okay, thank you very much.
What do you think is going to happen, out of curiosity?
I think the decision will likely be appealed. That's as far as I'm able to predict right now.
Yeah, I mean, it's going to be fascinating. I think the other thing that might become fascinating if Trump's reelected, whether or not we're going to have U.S. citizens trying to go to the Canadian border to claim asylum themselves. And we'll have to see how that plays out. But yeah, no, good question. Any other questions or comments? Well, oh, Bob, yeah.
Go ahead.
Mute here. Okay. Yeah. You mentioned the fact that when you go to sue the government over a case, that they just settle it so it never goes to court. So
Yes.
there's no case law. Do you have the option to push it through the court?
We do, but so typically what happens is they moot it. So like, let's say like recently we had an O1, which is for extraordinary ability, the Einstein visa for a spectacular businesswoman who had actually like gotten the O1 classification in the past, had a business in the United States in the tech sector. It was a really terrible decision by USCIS. Like I was fuming. So I actually said I would sue the government at no cost to her because I thought the decision was really bad. And I sent, we drafted our complaint. I filed the complaint in the Southern District of California. They have 30 days to respond to the complaint, right? And then Bob, what ends up happening is they call the service center where the case was denied, and they said, is this one worth really fighting? And they had to respond to the complaint by September 17th. Yesterday, we got the approval notice in the mail. So what they do is they moot out the basis for the litigation by approving the benefit that's sought, which almost requires you either to do an amended filing, but now we don't have a cause of action because the case was approved, or you have to withdraw. So
really you can't force it to go to court then, because
not on like a basis like that, not on a case like that. We've had some cases that have gone to court. Like we actually had a big win on summary judgment on an H-1B case where the government was trying to fight it, and they ended up creating bad case law for themselves, and it got picked up nationally, and it's like now it's a reference case when people are arguing for H-1B classification. So they're very I mean, the power that litigation has with this administration is pretty significant, because there's a big difference between like they're defending something because they like the policy and the effect it has versus whether or not they think they're within their right legally. So it's changed the game tremendously.